Welcome to Drishti Judiciary. This MCQ series for the Supreme Court Clerk Exam will sharpen your accuracy, strengthen concepts, and help you master the exam pattern. Let's begin with previous day's practice question. The question was, who has the last authority to explain the Constitution? President, Supreme Court, Chief Justice of India, or Attorney General of India? The correct answer is option D. The Supreme Court of India holds the ultimate authority to interpret and explain the provisions of the Constitution of India. According to Article 141 of the Constitution, the decisions of the Supreme Court are binding on all courts in India, while the President and the Chief Justice of India may play significant roles in legal matters. The power to provide the final and authoritative interpretation of the Constitution lies with the Supreme Court. The Attorney General of India is the chief legal advisor to the Government of India and represents the Union Government in legal matters, but they do not have the authority to explain the Constitution. Hence, B is the correct option. Let's start today's session. The first question is, which of the following is true about an ex parte decree under the CPC? It can be appealed by the defendant. It can be set aside if the defendant can show valid reasons for non-appearance. It can only be set aside by the High Court, or it is never set aside under any circumstances. The correct answer is option B. An ex parte decree is passed when the defendant fails to appear in court after receiving summons. However, the defendant can file an application to set aside the ex parte decree if they can prove that their non-appearance was due to valid reasons. Example, illness, not receiving summons, etc. The court has the discretion to decide whether to set it aside. Hence, B is the correct option. Next, under which of the following circumstances can a suit for defamation be filed according to the CPC? Only within 2 years of the defamatory statement, only within 1 year of the defamatory statement, only within 3 years of the defamatory statement, or defamation suits can be filed at any time. The correct answer is option C. A suit for defamation must be filed within 3 years from the date of the defamatory statement or publication, as per the Limitation Act 1963, Section 27. Hence, C is the correct option. Next, the President can issue a proclamation of emergency only on receiving a request from Prime Minister, request from Union Home Minister, written decision from Union Cabinet Minister, or written decision of Law Minister. The correct answer is option A. According to Article 352 of the Indian Constitution, the President can issue a proclamation of national emergency only on the written recommendation of the Cabinet headed by the Prime Minister. This recommendation must come from the Union Cabinet as a collective decision. The Prime Minister, as head of the government, leads this process, but the decision must involve the entire Cabinet. It is not solely the Prime Minister's individual request. Hence, A is the correct option. Next, in the case of Urmila Dikshit versus Sunil Saran Dikshit and others 2025, the Supreme Court addressed which key issue related to the rights of senior citizens under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. A. Whether a senior citizen can revoke a gift of property if the relative fails to provide care, even if the gift deed does not explicitly mention the condition of maintenance. B. Whether a senior citizen can demand financial support from children if no formal agreement was made. C. Whether the tribunal can modify the terms of a gift deed for the welfare of senior citizens. D. Whether the government should provide financial assistance to elderly citizens without family support. The correct answer is option A. In this case, the Supreme Court clarified the rights of senior citizens under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. The Supreme Court, however, interpreted the law liberally, noting that the law is meant to protect the elderly and should be applied with compassion. It ruled that the gift could be cancelled under Section 23 of the Act if the relative fails to provide care, even if the gift deed does not explicitly mention maintenance. This judgment highlights the court's stance on protecting the welfare of senior citizens and their right to revoke gifts if they are not properly cared for. Hence, A is the correct option. Next, in the case of Bairam Pestonji Gariwala versus Union Bank of India and others 1991, the Supreme Court addressed the validity of a compromise decree under which provision of the Civil Procedure Code 1908, Order 21 Rule 23, Order 23 Rule 3, Order 21 Rule 21, or Order 23 Rule 5. The correct answer is option B. The case of Bairam Pestonji Gariwala versus Union Bank of India and others 1991 is a landmark judgment concerning a compromise decree under Order 23, Rule 3 of the Civil Procedure Code 1908. The ruling emphasized that compromises are meant to definitively end litigation, and such amicable settlements should be encouraged to reduce case backlogs in courts. Thus, Order 23 Rule 3 allows for compromises through authorized agents like counsel, and consent decrees are valid even if signed by the parties' legal representatives. Hence, B is the correct option. Next, according to Section 14 of the Bharatiya Nyaya Sanhita 2023, which of the following statements is correct regarding the general exception in criminal law? A person can be exempt from criminal liability if they act under a mistake of law. B, a person is not criminally liable if they act in good faith, believing themselves to be legally bound by law. C, a mistake of fact does not exempt a person from criminal liability under any circumstance. D, a person is exempt from criminal liability only if their act is not punishable under any law. The correct answer is option B. Section 14 of the Bharatiya Nyaya Sanhita 2023 provides a general exception, stating that a person who acts under a genuine reasonable belief that they are legally bound by law or who is legally bound to act is not criminally liable for their actions. Therefore, if someone acts under a mistaken belief about the facts but is genuinely and reasonably mistaken, they will not face criminal liability under this provision. Hence, B is the correct option. Next, under Section 33 of the Bharatiya Nyaya Sanhita 2023, which of the following is true regarding acts that cause slight harm? Any act causing slight harm is considered a criminal offence. Acts causing slight harm that an ordinary person would not complain about are not offences. Acts causing harm to public property, regardless of the extent, are always offences. Or, this section applies only to acts of self-defense, not trivial harm. The correct answer is option B. Section 33 of the Bharatiya Nyaya Sanhita 2023 acts as a general exception, stating that acts which cause only slight harm and which would not lead an ordinary sense and temper person to complain are not considered criminal offences. This provision is intended to prevent trivial, unnecessary, or vexatious prosecutions for minor incidents. It serves as a safeguard against prosecuting individuals for minor actions that would not typically cause a reasonable person to feel aggrieved or harmed. Hence, B is the correct option. Next, in the case of Imran Pratap Ghadi versus State of Gujarat, May 2025, the Supreme Court discussed Section 173, subsection 3 of the Bharatiya Nagrik Suraksha Sanhita 2023. What is the primary purpose of this provision? To allow immediate arrest of individuals upon FIR registration for serious offences, to allow a preliminary investigation to verify if a prima facie case exists before FIR registration, to mandate a time-bound trial for all FIRs registered under serious offences, or to prevent the filing of FIRs for minor offences. The correct answer is option B. In Imran Pratap Ghadi versus State of Gujarat, May 2025, the Supreme Court highlighted Section 173, subsection 3 of the Bharatiya Nagrik Suraksha Sanhita 2023, which provides a safeguard against the immediate registration of FIRs for certain offences. The goal of this provision is to prevent frivolous or baseless FIRs from being filed and to ensure that genuine complaints are properly investigated before legal proceedings are initiated. Hence, B is the correct answer. Next, which of the following statements about evidence under Section 3 of the Indian Evidence Act is correct with reference to circumstantial evidence and its application in cases like Sharad Bridhi Chand Sarda versus State of Maharashtra 1984? A. Oral evidence includes statements made by witnesses regarding matters of fact, while documentary evidence includes documents and electronic records presented in court. B. Direct evidence conclusively proves a fact, whereas circumstantial evidence provides a complete chain of events but cannot prove a fact. C. Circumstantial evidence can only be used to support direct evidence but not to establish facts on its own. D. Circumstantial evidence is inadmissible unless it directly connects the accused to the crime scene. The correct answer is option A. Direct evidence conclusively proves a fact, while circumstantial evidence provides a chain of circumstances leading to an inference of the accused's guilt. The principles set out in the Sharad Bridhi Chand Sarda versus State of Maharashtra case, commonly known as the 5 golden principles of circumstantial evidence, outline the requirements for the admissibility of circumstantial evidence, emphasizing the need for a complete chain of evidence that excludes all reasonable hypotheses of innocence. Hence, A is the correct option. The last question is, in the landmark case of Omkar Ramchandra Gond versus State of Maharashtra, the Supreme Court dealt with which of the following issues regarding disability assessment for medical education admissions? A. Whether candidates with any percentage of disability are automatically disqualified from medical courses. B. Whether rigid disability percentage thresholds for medical courses violate the constitutional principles of equality. C. Whether candidates with speech and language disabilities should be denied medical education entirely. Or D. Whether candidates with disabilities should be given preferential treatment in medical education admissions. The correct answer is option B. The court emphasized that disability assessment should be based on individual functional capabilities rather than mechanical application of percentage thresholds. It ruled that functional capability must be assessed on a case-by-case basis, ensuring that candidates are not disqualified solely based on their quantified disability percentage. Hence, B is the correct answer. Now it's time for the practice question. The question is, inherent powers under section 482 of the CRPC can be exercised by the High Court, the Sessions Court, the Magistrates Court, or both 1 and 2. Send the answer to this question in the comment section. That's all for today's MCQ session. If you found this helpful, don't forget to like, share and subscribe to the Drishti Judiciary YouTube channel. See you in the next session. Keep preparing.